Subsection 6. Revocation of wills and testamentary dispositions. Article 828. A will may be revoked by the testator at any time before his death. Any waiver or restriction of this right is void. Article 829. A revocation done outside the Philippines by a person who does not have his domicile in this country is valid when it is done according to the law of the place where the will was made, or according to the law of the place in which the testator had his domicile at that time, and if the revocation takes place in this country, when it is in accordance with the provisions of this code. Article 830. No will shall be revoked except in the following cases. Number 1, by implication of law. Number 2, by some will, codicil, or other writing executed as provided in case of the wills. Or by burning, tearing, cancelling, or obliterating the will with the intention of revoking it by the testator himself, or by some other person in his presence and by his express direction. If burned, torn, cancelled, or obliterated by some other person without the express direction of the testator, the will may still be established and the estate distributed in accordance therewith if its contents and due execution in the fact of its unauthorized destruction, cancellation, or obliteration are established according to the rules of court. Article 831. Subsequent wills which do not revoke the previous ones in an express manner annul only such dispositions in the prior wills as are inconsistent with or contrary to those contained in the latter wills. Article 832. A revocation made in a subsequent will shall take effect, even if the new will should become inoperative by reason of the incapacity of the heirs, devises, or legatees designated therein, or by their renunciation. Article 833. A revocation of a will based on a false cause or an illegal cause is null and void. Article 834. The recognition of an illegitimate child does not lose its legal effect, even though the will wherein it was made should be revoked. Subsection 7. Republication and revival of wills. Article 835. The testator cannot republish without reproducing in a subsequent will the dispositions contained in a previous one which is void as to its form. Article 836. The execution of a codicil referring to a previous will has the effect of republishing the will as modified by the codicil. Article 837. If after making a will, the testator makes a second will expressly revoking the first, the revocation of the second will does not revive the first will, which can be revived only by another will or codicil. Subsection 8. Allowance and disallowance of wills. Article 838. No will shall pass either real or personal property unless it is proved and allowed in accordance with the rules of court. The testator himself may, during his lifetime, petition the court having jurisdiction for the allowance of his will. In such case, the pertinent provisions of the rules of court for the allowance of wills after the testator's death shall govern. The Supreme Court shall formulate such additional rules of court as may be necessary for the allowance of wills on petition of the testator. Subject to the right of appeal, the allowance of the will, either during the lifetime of the testator or after his death, shall be conclusive as to its due execution. Article 839. The will shall be disallowed in any of the following cases. Number 1. If the formalities required by law have not been complied with. Number 2. If the testator was insane or otherwise mentally incapable of making a will at the time of its execution. Number 3, if it was executed through force or under duress, or the influence of fear or threats. Number 4, if it was procured by undue and improper pressure and influence on the part of the beneficiary or of some other person. Number 5, if the signature of the testator was procured by fraud. And number 6, if the testator acted by mistake or did not intend that the instrument he signed should be his will at the time of affixing his signature thereto. Section 2. Institution of Heir. Article 840. Institution of heir is an act by virtue of which a testator designates in his will the person or persons who are to succeed him in his property and transmissible rights and obligations. Article 841. A will shall be valid even though it should not contain an institution of an heir, or such institution should not comprise the entire estate, and even though the person so instituted should not accept the inheritance or should be incapacitated to succeed. In such cases, the testamentary dispositions made in accordance with law shall be complied with, and the remainder of the estate shall pass to the legal heirs. Article 842. 1. Who has no compulsory heirs may dispose by will of all his estate or any part of it in favor of any person having capacity to succeed. 1 who has compulsory heirs may dispose of his estate provided he does not contravene the provisions of this code with regard to the legitime of said heirs. Article 843. The testator shall designate the heir by his name and surname, and when there are two persons having the same names, he shall indicate some circumstance by which the instituted heir may be known. Even though the testator may have omitted the name of the heir, should he designate him in such manner that there can be no doubt as to who has been instituted, the institution shall be valid. Article 844. An error in the name, surname, or circumstances of the heir shall not vitiate the institution when it is possible, in any other manner, to know with certainty the person instituted. If among persons having the same names and surnames, there is a similarity of circumstances in such a way that even with the use of other proof, the person instituted cannot be identified, none of them shall be an heir. Article 845. Every disposition in favor of an unknown person shall be void, unless, by some event or circumstance, his identity becomes certain. However, a disposition in favor of a definite class or group of persons shall be valid. Article 846. Heirs instituted without designation of shares shall inherit in equal parts. Article 847. When the testator institutes some heirs individually and others collectively, as when he says, I designate as my heirs A and B, and the children of C, those collectively designated shall be considered as individually instituted, unless it clearly appears that the intention of the testator was otherwise. Article 848. If the testator should institute his brothers and sisters, and he has some of full blood and others of a half blood, the inheritance shall be distributed equally, unless a different intention appears. Article 849. When the testator calls to the succession a person and his children, they are all deemed to have been instituted simultaneously and not successively. Article 850. The statement of a false cause for the institution of an heir shall be considered not written, unless it appears from the will that the testator would not have made in institution if he had known the falsity of such cause. Article 851. If the testator has instituted only one heir, and the institution is limited to an aliquot part of the inheritance, legal succession takes place with respect to the remainder of the estate. The same rule applies if the testator has instituted several heirs, each being limited to an aliquot part, and all the parts do not cover the whole inheritance. Article 852. If it was the intention of the testator that the instituted heir should become sole heirs to the whole estate or the whole free portion, as the case may be, and each of them has been instituted to an aliquot part of the inheritance, and their aliquot parts together do not cover the whole inheritance or the whole free portion, each part shall be increased proportionally. Article 853. If each of the instituted heirs has been given an aliquot part of the inheritance, and the parts together exceed the whole inheritance or the whole free portion, as the case may be, each part shall be reduced proportionally. Article 854. The preterition or omission of one, some, or all of the compulsory heirs in the direct line, whether living at the time of the execution of the will or born after the death of the testator, shall annul the institution of heir, but the devices and legacies shall be valid insofar as they are not inofficious. If the omitted compulsory heirs should die before the testator, the institution shall be effectual, without prejudice to the right of representation. Article 855. The share of a child or decedent omitted in a will must first be taken from the part of the estate not disposed of by the will, if any. If that is not sufficient, so much as may be necessary must be taken proportionally from the shares of the other compulsory heirs. Article 856. A voluntary heir who dies before the testator transmits nothing to his heirs. A compulsory heir who dies before the testator, a person incapacitated to succeed, and one who renounces the inheritance, shall transmit no right to his own heirs, except in cases expressly provided for in this code. Subsection 3. Substitution of heirs. Article 857. Substitution is the appointment of another heir so that he may enter into the inheritance in default of the heir originally instituted. Article 858. Substitution of heirs may be simple or common, brief or compendious, reciprocal, or fideikommissary. Article 859. The testator may designate one or more persons to substitute the heir or heirs instituted in case such heir or heirs should die before him, or should not wish, or should be incapacitated to accept the inheritance. A simple substitution without a statement of the cases to which it refers shall comprise the three mentioned in the preceding paragraph, unless the testator has otherwise provided. Article 860. Two or more persons may be substituted for one, and one person for two or more heirs. Article 861. If heirs instituted in unequal shares should be reciprocally substituted, the substitute shall acquire the share of the heir who dies, renounces, or is incapacitated, unless it clearly appears that the intention of the testator was otherwise. If there are more than substitute, they shall have the same share in the substitution as in the institution. Article 862. The substitute shall be subject to the same charges and conditions imposed upon the instituted heirs or heir, unless and testator has expressly provided the contrary, or the charges or conditions are personally applicable only to the heir instituted. Article 863. A fideikommissary substitution by virtue of which the fiduciary or first heir instituted is entrusted with the obligation to preserve and to transmit to a second heir the whole or part of the inheritance shall be valid and shall take effect, provided such substitution does not go beyond 1 degree from the heir originally instituted, and provided further that the fiduciary or first heir and the second heir are living at the time of the death of the testator. Article 864. A fideicommissary substitution can never burden the legitim. Article 865. Every fideicommissary substitution must be expressly made in order that it may be valid. The fiduciary shall be obliged to deliver the inheritance to the second heir without other deductions than those which arise from legitimate expenses, credits, and improvements, save in the case where the testator has provided otherwise. Article 866. The second heir shall acquire a right to the succession from the time of the testator's death, even though he should die before the fiduciary. The right of the second heir shall pass to his heirs. Article 867. The following shall not take effect. Fideicommissary substitutions which are not made in an express manner, either by giving them this name or imposing upon the fiduciary the absolute obligation to deliver the property to a second heir. Number 2, provisions which contain a perpetual prohibition to alienate and even a temporary one beyond the limit fixed in Article 863. Number 3, those which impose upon the heir the charge of paying to various persons successively beyond the limit prescribed in Article 863 a certain income or pension. Number 4, those which leave to a person the whole or part of the hereditary property in order that he may apply or invest the same according to secret instructions communicated to him by the testator. Article 868. The nullity of the fideicommissary substitution does not prejudice the validity of the institution of the heirs first designated. The fideicommissary clause shall simply be considered as not written. Article 869. A provision whereby the testator leaves to a person the whole or part of the inheritance and to another the use of rank shall be valid. If he gives the use of rank to various persons, not simultaneously, but successively, the provisions of Article 863 shall apply. Article 870. The dispositions of the testator declaring all part of the estate inalienable for more than 20 years are void.